Good morning, Mr. Bowden.
Good morning. I saw that.
Good morning, Judge. How are you?
Good morning, Reem. I'm in very good order. Many thanks. Are we all present and correct to begin our proceedings today?
Yes, Judge.
Yes. Well, good morning, Mr. Bowden.
Good morning, sir.
Are you ready to proceed with the continuation of your cross-examination? And
yes, I am.
Do we have Mr. Jabara?
I see him, sir.
Yes, I'm here, Your Honor.
Okay. At the moment, I don't see him. So what initial should I circle? Any help, Mr. Montague-Smith?
I'll do my best, Your Honor. It may be AG, perhaps.
AG, okay.
One of the AGs, I'm afraid. There's two of them.
Yeah.
Your Honor, before we proceed, I just wanted to raise one minor thing that's arisen this morning.
Yes, go ahead.
It's a short point. It's more of a moan, I'm afraid, but we've been asking repeatedly that documents not be added to the bundle, but at least without letting us know in advance, Your Honour. As you'll know, in a physical trial, in order to add documents to the bundle, there's a process because you need to show them to the other side, and then you need to ask the judge if it can be. And whereas at the moment, documents are simply being added because both parties have access to the trial bundle. So there are some new documents in the bundle this morning. We only discovered it ourselves, so we weren't told about it. They're at I-16. Is the new document. I don't object to those particular documents going in, but Your Honour, there's obviously going to be a part of the process going forward, and some discipline needs to be imposed on this because it will get incredibly chaotic if documents keep coming in. It may be a wider problem for the court with these electronic bundles that parties just have the ability to do that, but plainly they oughtn't to be doing that. So it's not a decision for you at this point, but it is simply an observation, Your Honour.
Yes. Well, once we adjourn this morning, London time, there must be no additional documents put onto the e-bundle without notice, both to the other side and to myself, because otherwise it will be extremely difficult to get on with writing a reserved judgment. One day the bundle may be from A to P, and then the next day it may be from A to Z. So is that clearly understood between the parties? There must be no additional material of any sort put onto the e-bundle without notice to the other side and permission from myself. Right.
Understood, John.
Right. And now I still haven't seen, let's try the other AG. He is he in the offices of your solicitors, Mr. Montague-Smith, or is he in his office at?
He's in the Adelshire Goddard offices, Your Honour. So there's two entries. If Your Honour has the participant list, there's a tab at the top if you see that.
Mr. AJ, if you please speak, the video will appear on the screen.
Yes, I'm here.
And is
Sorry
your
to
camera?
interrupt. This is Adil from IT. Sorry to interrupt.
Yes,
Is
thank you.
Yeah.
Is Mr. Jabbarah's camera on?
Yes.
Adil, I don't know whether you can help.
Yeah, please make sure, sir, you have the screen maximized. Is it full screen or it's a half?
No, it's a full screen. On the left-hand side, I can see both counsel. On the right-hand side, I have two sets of initials, RA and AK. So that's one of them is Reem,
Yes.
and the other one is perhaps yourself. I
Me,
don't
yeah,
know.
exactly. We can see him very well. Mr. Ajik, please, if you can speak few words, we want to see whether this will appear on the screen. Please speak.
Yes.
Perhaps you count to 10, Mr. Jabira.
Yes, Mr.
Yes.
Jabira.
I'm speaking now.
In order to assist, sir, we are about to change the name from AG Middle East to AG brackets KJ so that you can identify which one that you need to pin. Someone's just about to go into the room in order to do that, someone in the IT, and that will be done shortly. I think it may mean that Mr. Jabera needs to go and then come back again, but it'll be momentary.
AG or what?
We're going to change the name.
Okay.
Now I see him. There's looks like someone from the technical department of Adelshire Goddard is in the room assisting, but I now see the witness, so perhaps we could just proceed. Thank you very much indeed for your help.
Thank you.
Well, as I said just now, Mr. Jabbarah, good morning.
Good morning.
We're going to continue with the questioning, first from Mr. Bowden and then possibly also from Mr. Montague-Smith. And so let's get underway now.
Thank you. Good morning, Mr. Jabira.
Good morning, Mr. Bowden.
Can we go to document I3, and that is page I92, please?
I3.
Yeah, the document is I3. Perhaps type in I91 and we'll get to the first page.
I91, yes.
Yeah.
Okay. I have a translation of.
Yes, that's a translation of the Hpa report. Correct me if I'm wrong. Dated the 9th of July, 2018.
Yes.
Now, just tell the court a little about this report. How did you come to meet Hpa?
That was a requirement from the public prosecutors. They said you should appoint an accounting office to put together all the detailed documents, and this accounting office should be a listed accounting office approved by the public prosecutors. And our advisor at that time selected Hpa as one of those accounting office in the list.
And did you make the final selection?
Actually, it was recommended. We accepted the recommendation of our advisor.
Now, I think that they were instructed in June, correct?
as far as my recollection, yes. I mean, it could be a few weeks after this was issued. Yes.
Did you meet with the HPA during the time that they were putting together this report?
Yes.
How many times?
At least 3 times, as I recollect. We told them exactly about all the information, and we provided all the documents they requested from us during those meetings.
Okay, and we were looking. You and I were looking at some of those documents yesterday, weren't we? When we accessed them from the 24 series documents set out at internal page 53 of the EY report. Do you agree?
Yeah, the EY report was one of the documents they requested to see.
Well, just before we go on, then let's have a look at what you provided to them. So can you go down to its document H14, and if you type in I397.
I397.
Yeah.
That's the page number.
97.
I397. Okay. Do you see that? And the first thing you see in the top middle of the page is page 1 of 242. So did you provide HPA with, well, certainly not less than 242 pages of documents from your accounting system?
We provided everything they required, and bear in mind that before they come to the picture, we already had a lot of files prepared in this auditing and investigation. So we provided everything they requested from us.
So you had all these files already collated and ready to go in your office, is that right?
Again, please. The question again?
Yeah. Did you have these 242 pages already collected in your office?
No, I don't recall it was collected in one place. I mean, we had to get some from our side, some from what our advisors already had and put together. I mean, I don't recall that it was all put together in one place by the time these people were hired.
Did this 242 pages include the documents that Mr. Taj had collected following the meeting on 24 January 2018?
Yeah, I believe, yes.
Yeah. Were all the documents collected by Mr. Taj, or was it only some of them?
I can't tell you. I mean, whatever they requested, they got it. I mean, they went through all the documents that they requested, and we asked the people in the finance and others to bring whatever they requested for their report.
Yeah. Who was in charge of this process?
I was in charge with Mr. Bickley.
Okay. Did you ever keep is there a record available of what documents Mr. Taj actually collected?
There must be, but I'm not sure because he was conducting at that time internal audit, and he made whatever required for him to reach to that conclusion, but I cannot tell you that I know exactly what are the files.
You've been managing the litigation process as well through till today, haven't you?
Mr. Bickley was our advisor, and I was with him in that.
Didn't Bill Bickley retire?
He retired only in November of 2000.
Could I just have the date, the year when he retired, please?
Yeah.
Mr. Jabra, what year was it?
It's November It's November 2020, I would imagine. Yes, 2020.
Thank you.
So since his retirement, you've been doing it yourself, correct?
Yes.
Do you recall that recently, and indeed since the 24th of June 2021, we have been seeking the Word copy of the internal audit report said to have been written by Mr. Taj?
Yes.
Yeah.
Our advisors informed me that, yes.
Yeah. And have you conducted any searches for that or caused anybody to search for that document?
We always had that document. What was requested from our advisor is to get the original document in the system.
The Word copy, yeah.
The Word copy in the system.
And
that was the first time where anybody requested that from us, but we always had that that copy of the report.
Well, prior to the 20th of June 2021, you hadn't actually deployed the internal audit report as evidence in this litigation, had you?
No, this is
what I'm saying. Sorry.
If I understand I have to understand your question well.
Yeah. Only in your witness statement and Mr. Beckley's witness statement filed on 20 June 2021 was for the first time any reliance placed upon the internal audit report, correct?
No, we used this internal report before in our advisors used the result of this report in the litigation.
Yeah. Okay. Now, just can you say what happened to the Word copy of that internal audit report? Do you know?
No, I don't know, but we have a copy of the report.
Yeah, you've got the PDF copy, haven't you?
We have the PDF copy, yes.
Yeah. Just explain, if you could, what happened to the Word version?
I really don't know. I can't tell you something I don't know. When this was requested, we searched for it and we did not. Okay. And I have to explain one thing here, Your Honor, that when somebody makes a report and he wants to issue it, usually it's safe to issue it as a PDF, not as a Word, because that's the only way to keep it as is. Nobody can manipulate it. Now, we could not get to the Word document that was requested from us originally for the same.
Mr. Beckley told the court yesterday that he had the Word version because he made some changes to the report prior to it being published. And he couldn't have done that on the PDF, could he?
No. What I know is that that was prepared by Mr. Taj, and Mr. Beckley made adjustments that is not changing what he was minting in his report, but to make it from a language and from English better. But he did not actually change the fact that was put in that. Now, after he does that, Taj issued that report in PDF.
Sure, but in order to make those adjustments, he must have had the Word version. Do you agree?
Yeah, it could be that it's given to him in Word version. I was not actually at that time. I was not there when this happened. I've been informed later by Mr. Beckley.
Have you searched, or have you still got Mr. Beckley's old computer?
Well, we have his records with us, yes.
Yeah. Have you searched that for the Word version?
Yes, we did.
Is it there?
It's not there.
Okay. Well, I think you agree with me that it must have been there, correct?
I wouldn't, I cannot be sure about that because.
Well, I think you can, because you've just told me that Mr. Beckley made adjustments to the language, etc., used by Mr. Taj, correct?
Correct. This what was Mr. Beckley told me, yes.
Yeah, and you've also agreed with me that that would have been done on the Word version. Agreed?
Yes.
So you therefore agree that Mr. Beckley did have the Word version of the internal audit report on his computer, don't you?
Yes, it could be, yes.
Yeah. No,
But
not could be.
We could not
It
find
would
it,
be.
actually.
It's not could be, but would be. Do you agree?
It could be because I was not there. There is a possibility that they were together and then he made adjustment at that time on his computer and his touch computer.
Yeah.
Because
Right.
this is not something that it's a normal and it's the job of Mr. Beckley to do that. Maybe they were together and he showed him that this is my final and he had them in his computer. This is also a possibility.
Well, as part of your duty of finding that document, did you not think to make that inquiry?
There was an inquiry made.
Was that particular inquiry made whether Mr. Beckley did that on his own computer or he did it on Mr. Taj's computer?
We searched both. We searched the computer of Mr. Beckley, the computer that Mr. Taj used, and in both cases it was not there.
Okay, so the answer is that it was previously on one or both of those computers, and it is now on neither. Is that your evidence?
I would say that we search in both computers, we search in our system, we did not find the original document creation of that report, a Word document.
That is not the answer to my question. Okay, my question was that you agree that it was either on one or both of those computers, don't you?
Yeah, but what I was not, because I was not there, Mr. Bowden, I cannot say that a Word document was or was not in either of the computer. We searched possibilities of having a Word document in either ones, and I could not find it.
Are you being evasive? Is that what you're being? Are you trying to help the court with your evidence, or are you just sort of thinking up a new answer as we go along every time?
Yeah, this is the fact. I was swearing in Quran. This is the fact. I was not there. I requested to employ a search. I did that with IT department. I did it with a system that's available to us, and even we went further to find that because it's also in our interest to see that. I mean, this is our interest to get this original document. We already said that it was prepared by Mr. Taj and it was helped by Mr. Beckley in a language. We said that, so there's nothing preventing us from getting to the original one.
Mr. Bowden, I might be able to shorten things.
Yeah,
the witness has accepted that for Mr. Beckley to smarten up the language, if I can paraphrase Mr. Beckley's evidence, he would have worked off a Word version that had been produced by Mr. Taj. And it's the witness's evidence that on a search of Mr. Beckley's computer and Mr. Taj's computer, no trace could be found of the Word document. I think the rest is a matter of submission as to what conclusions should be drawn from that and what is relevant.
Thank you, sir. Let's go back, shall we, to the actual report itself, and this time I will direct you to page I-93.
I-93.
Yeah, I for Indigo.
So this is the HPA report, is it?
Yes, sir. And we're on page 2 now.
Yes, yes, I'm there.
We started at page 1. Now we're
Yeah.
on page 2.
Yeah.
Yes.
Now, bottom of page I-92, he's talking about, this is the introduction, and it sets out the parties, the experts, the nature of the consultant expert's assignment, correct?
Yeah, it says that the meeting of the attorney first party, a representative of the corporate first party, and discussion of subject matter of the report. Yes.
So it records meeting with you, correct?
Yeah.
And if we just scroll up from there, it says, I will undertake the assignment entrusted to me as follows. Conclude the financial and administrative irregularities that the second party have committed against the first party, which resulted in causing the first party to sustain heavy losses and serious harm. Do you accept that the report starts from the position that Mr. Abdelazim has stolen money and caused you heavy losses and serious harm?
No, we did not tell him stealing, and we said the same position we held, and we were very careful with the guy. We said we held with the same words that was giving at that time to either the public prosecutors or it was given in our proceedings with the court. We did not exceed that, and we did not ask the guy to go for a specific words like stealing, as you just mentioned to me.
Well, why does he say that then? He says that.
Mr. Jabra, look at the last bullet point of those 3 bullet points. Conclude the amounts that second party unrightfully appropriated from the first party.
Which is the bullet number 3?
Yes, under the heading second, the consultant expert's assignment.
Yeah. Copy and then a copy. Let me locate that so that I can read it. First, I have in page I-93, number 2 and 3, right?
Well, it's under the heading.
I-92. One page up.
Yes, we're on page 192.
Yes, the last bulletin.
And
yes.
and under the heading second, the consultant's expert's assignment, there are 3 bullet points.
Correct.
I was directing your attention to the 3rd bullet point.
Yes, it was concluded the amount that second party unrightfully appropriated from the first party. Your question, Your Honor.
Well, it was put to you that from the outset, the brief for HPA was to produce a report to demonstrate that Mr. Abdelazim had unrightfully appropriated these sums. And unrightfully appropriated, I think, can fairly be construed as improperly took for himself. Do you agree?
Yes, I agree. And at that time, Your Honor, it was clearly for us, the position is that if this amount is transferred from the company account to the personal account of Mr. Abdelazim without proper approval, it's unauthorized, and it's unauthorized. That means it is unrightly dealt with, because it is the money of the company and it's transferred to his personal account. So that was the position.
I see.
I have to add one more thing, Your Honor, that
Yes, do.
HBA is coming with the assignment to give a report to public prosecutors, and that's why the way he was asking question is it's not a normal audit or normal review. He was coming to see where are the areas where there is irregularities or unauthorization or any suspicions, and he was asking, what is your suspicion, so that those areas will be covered and presented to the public prosecutors with facts.
Yes.
So do I take it from your answers to His Honour that you accept that HPA were directed to conclude that Mr. Abdelazim had stolen the money?
No, they were not instructed to do that. They were instructed to review all the documents that is involved in our approach to the public prosecutors.
All right, come down a page to page 193, if you'd be so kind. And you see the numbers 2 and 3.
Yes.
And then the next paragraph. And so he's still setting out the scope of his assignment there, do you agree?
Document of proof submitted by first party attorney, which confirm with the first parties. Yes, he was listing that, yes.
It says examining and analysing the documents submitted by the first party's attorney. That's your lawyer, correct?
Mm-hmm. Correct.
And then it goes on to say this, doesn't it? First party's letter assigning me to develop a consulting accounting report intended for concluding the nature of the relationship between the industrial group and Mr. El Fadil, concluding the administrative and financial irregularities that he committed at the company, as well as the amounts he has unrightfully appropriated from the company. See that? That describes a letter that you wrote to HPA auditors, doesn't it?
We did not write a letter to...
Well, this says that you did.
No.
So what do you say to that?
We did not send a letter asking them and directing them to do this. This was the list of what he was describing what he's going to do, and we did not send a letter that gave him instruction to issue a report with this direction.
Did your lawyers send a letter asking him to conclude that?
Did I what?
Did your lawyers send such a letter? I mean, it says it's from you, but I'm asking you if it's possible that the expert is mistaken and that it was from your lawyers on your behalf. Is that a possibility?
It could be that they told him exactly all the circumstances of why he was appointed. And remember also that he is a listed office by the public prosecutors. We cannot hire anybody. We should hire an office from the list.
Well, obviously, there is a letter about which is directed to HPA and instructs them to conclude the administrative and financial irregularities committed at the company and amounts unrightfully appropriated from the company by Mr. El Fadil, isn't there?
Yes, there is an appointment letter, official appointment letter.
Is that in the evidence? Do you know where that letter is now? Can we see it?
Yeah, at that time we gave them appointing them officially.
Is it something we should come back to? Perhaps my learned friend can find it during the next adjournment and we can have a look at it. Right. Let's move on.
Mm-hmm.
I'll just ask you to, it's probably easier to scroll through this letter, this document to I-197, if that's okay with you. I-197.
Just scroll up, I suggest, from the page we were on, just 2 or 3 pages on, to 197.
Mm-hmm.
Do you have that page now?
Yes.
Okay. Now, one of the documents you gave them was the internal audit report, which specified the payments obtained from the company to the account of Mr. El Fadil, correct?
Yeah, one of the documents.
Yeah.
Mr. Fadil, I
And
don't remember all this now.
If we just go 1, 2, 3, 4, 5 lines up from the bottom of that paragraph, it says that the report reveals that he fraudulently appropriated from the company's account an amount that exceeds AE 1.3 million in light of the investigations and audit that have been conducted, indicating that other unauthorized payments may be revealed. So do you think that's a fair conclusion of what the internal audit report says?
If the amount is transferred from the company account to his personal account, and he is in his position and has the authority of transfer, so at that time it was looked at it only that way.
Okay. So if money was paid from the company to Mr. El Fadil, it was reasonable to conclude without any further inquiry that it was fraudulent. Is that correct?
No, it's not correct, because many times that was happened when he was getting reimbursed for amount already properly authorized, properly documented, and properly presented, and that it happened. Now we're talking about those amounts that was not authorized and that amount that was a surprise. Even with Mr. Al Fadil got the chance to inform us about when we had this issue with the 610. Even at that time, this was not mentioned by Mr. Al Fadil. That we also have others payment I made.
I put it to you, that evidence is wholly incredible. Just nonsense. You are making that up, aren't you?
I'm sorry, Mr. Bowden, I did not make it up. It's the fact. And I can explain what I'm saying.
Do you know Mr. Raghavanshi, Mr. Jatesh Raghavanshi?
I answered that yesterday, Mr. Bowden. Yes, I know him.
He gave evidence yesterday, and would it surprise you to know that he told His Honour that he had never heard of EY doing a report at the company? Do you accept that?
It is hard for me to accept that, because the E&Y were making inquiry on financials, and there was people in the department other than him, and they were involved in getting documents. Now, I don't know why he's saying that. Now, I cannot comment on his witness.
So is it a surprise to you to hear that he
I
was
heard, yes, it was a surprise to me to hear. I was thinking about yesterday, and then you know that he left the company less than a month from that time. So it could be that at that time he was in transition, and that's why he was not involved. That's also possible.
Well, that's not true, is it? Because
it is true, Mr. Bowden. I am sorry, because he left on the 21st.
correct. And what day were EY appointed?
They appointed actually beginning of April. But Mr. Bowden, you have to understand that they don't start immediately the first day asking everybody. I mean, they put together whatever they need. They go to the system, they get the information, and then they decide what further files we need to do. So I will not take it as if Mr. Jatesh doesn't know about it, that we kept it hidden.
Okay, go to page I1.
Page I1.
I1.
Page I1, okay.
EY started on the 2nd of April, didn't they?
That's correct, and he left.
3 weeks
19
later.
days after that. So, Mr. Bowden, the guy was in transition. This is what I concluded yesterday, giving him the benefit of doubt that he was in transition. So, if Mr. Jatesh didn't know about it, he cannot ask me now to agree with you that we kept it hidden.
Okay. Did you listen to the evidence of Mr. Jatesh yesterday?
Most of it, yes.
Okay. Bit of a surprise.
Sorry, was there an objection to that?
Yes, I don't see why that's a surprise. This witness has corporate responsibility for the litigation. It's the most natural thing in the world that he is, as if this were a face-to-face meeting, instead of sitting in court to hear the evidence, he has access to the virtual system, and here's the evidence.
Okay, fine. I don't make any objections, sir, and if I had...
Well, you're not in any position to make any objection, and I think that sort of remark that came from you would have been better unsaid. So let's get on.
Back, Mr. Okay, but just before we move on from Mr. Jatesh, he also said, and you would have heard it, that he had kept all of the transactions relating to Mr. Abdelazim on a spreadsheet in the event that anybody asked him for it. Do you recall that evidence?
Yes, I recall he said that, yes.
And he also said that other than the defendant and Mr. Taj, nobody did ask him for it, correct?
Yes, I heard that too.
Did you ever instruct highly professional auditors to speak to Mr. Jatesh?
We allow them to speak to the department. At that time, we had the head of the department. We have a layer above Mr. Jatesh, and he has colleagues also in Dubai, in Saudi Arabia. You have to understand also, I have the court to understand that part of those transactions related to operation in Saudi Arabia, because the scope of E&Y is to look at the whole payment process and to make sure that the payment process did not have any irregularities. So it was not only for that specific. So a lot of the finance department in our operation in Saudi Arabia were involved in providing all kind of documents to E&Y. So yes, I did not introduce Mr. Jatesh to E&Y. I did not have to. Taj at that time was enough to cover for that. And we had also managers in operation in Saudi Arabia reporting to Taj, they took care of it.
Okay. Can we go down to page I-104, please?
I-104. Yeah.
And this deals with the conclusions of the report, doesn't it?
Yeah, this is the translation in English. Yes, I can.
Yeah.
Yes, it is.
And you see just above the numbers 6-3.
6-3, yes.
3 lines up, which proves that the second defendant was deliberately acting in bad faith towards the company to cause harm thereto and unrightfully appropriate its money. That was what HPA concluded from their investigation. Do you agree?
Yes.
And then at 6.3 goes on and it deals with the amounts which were stolen. And I think that it copies the report or the table that we've seen, which was attached to the internal audit report. Do you agree?
1 minute, please, Mr. Fadil, if you allow me. I am at 6.3.
I think the table is on page 105. Is that right, Mr. Barton?
Yes, sir.
Yeah. Mm-hmm.
And then, so it's gathered up both the amount of 1.3 and the further amount of 1.4, which was later identified going back to 2013, correct?
Correct.
And then it has tallied that up and concludes that the total of the amounts that the second party unrightfully appropriated from the first party and without informing it. Okay, but nowhere in this report is there any analysis of the amounts said to be stolen, in what circumstances they were paid to Mr. El Fadil, and whether or not they were in fact reimbursements of expenses which he was required to pay on behalf of the company. Is there?
It's I read the conclusion and I say, yes, this is the conclusion of the report. I just want to know what's your question about this that I can answer.
What I'm saying is, do you agree with me that this report only has conclusions? It does not have analysis.
At that time, the guy, not the guy, the firm, HBA, did this conclusion and they reported it to the public prosecutors on their findings. I mean,
yeah. But do you agree with me that there is no analysis within this report which supports the conclusions drawn in the report?
Yeah, but the situation is the other way around. When we found out that a vice president of finance decided to make a transaction from the company account to his account and to make it in such a way that is coming with a huge amount, and that was not previously pre-approved or even reported later on, and we have to discover that with an internal audit. That by itself was something that Mr. Al Fadil should have brought all the evidence if he has approved pre-approval or not. But if you just have the using the authority to make in the system transfer to transfer from the company account to his personal account, that by itself was was against the policy and against what he signed not to do for himself.
Did you see Mr. El Fadil's evidence about the HPA report? And that is that he didn't see it until he was called to speak to the prosecutor, and the prosecutor was reading from it. And that the prosecutor asked him whether or not he had ever spoken to HPA. Do you recall that evidence?
I don't recall it, but I can tell you how this works.
Yeah.
The Hpa report was ordered by the prosecutors in order to be in the hands of the expert. The expert exchanged this with with Mr. Al Fadil for him to answer it, and that's exactly what happened. So Mr. Al Fadil hired his accounting office with the evidence, and he answered to HPA. Again, there was exchange of answers. So the expert was the one that's responsible to present and exchange those evidences between us and Mr. Fadil.
At any time prior to the completion of this HPA report on the 9th of July 2018, to your knowledge, did HPA speak to Mr. El Fadil?
No, I don't think they spoke to him.
Okay, let's go down to page I-108.
I-10.
Yeah, it's just one page down, sorry.
One page, okay.
And do you see there, third, there is an amount of AED 2724369.29 is payable by the second party to the first party as a result of having second party unrightfully appropriated the said amount for himself without informing the first party. Correct?
Correct.
That's the report it's just a tally up, isn't it, of the amounts which you said had been stolen.
Yeah, I disagree with you that the report was this way, the way you describe it. The amount that was transferred from the company account to the personal account of our financial vice president of finance was done without the authorization to make it, and that's why the first thing, from their opinion, the first thing is this is now owing to the company, and then if the other party has enough to prove that was, then it will be paid to him. So this is the mentality that this office came with us. I mean, this amount has been transferred to his account. He is a financial manager, and for just to make the court aware that financial managers, when it comes to unauthorized transactions, they always dealt with that incident with a high level of suspicion because of their sensitive positions. If this was that was a other position, it may not have that sensitivity. And what they are saying in principle, that this amount that is transferred from the bank company account to the financial vice president financial account has to be returned to the company unless there is a proof that it's owing to him, and then at that time the company will do it with the right way. So that was the main
Mr.
position.
I'm so sorry to interrupt you, but we've seen the word fraudulently in this report. One of the conclusions reached by HPA was that Mr. El Fadil had acted fraudulently. Now, that, of course, connotes not just a want of authority, but with a dishonest intention, that he was taking money that he was not entitled to take. It'll be a matter for me reading the whole report and coming to certain conclusions on it. But I give you the opportunity to respond to the point that I'm putting to you. Do you accept that the conclusion in this report that Mr. El Fadil had acted fraudulently is not consistent with the view that this expert is saying that an explanation from Mr. El Fadil is required? And if there's no good explanation, then it would appear that he has fraudulently obtained the money. The report concludes, without having any input from Mr. El Fadil, that he acted fraudulently.
Yes, Your Honor. What happened even at that stage, that we did not have from Mr. El Fadil explanation of why he did that. Immediately after the discovery of 610, we had the chance that Mr. El Fadil would come and say that there was transfers done. I did it because of 1, 2, 3. He can also bring himself all those evidence. Wherever we reached conclusion in October of 2018 could have been brought efficiently and by Mr. El Fadil himself, and the company wouldn't get to that conclusion if that was happened. I'm saying that because in my statement I mentioned that I had myself a chance to speak to Mr. El Fadil after that incident, and I asked him, it is for your benefit that the audit is done to clear your case. And then after the case is cleared, it's your decision what to do, to continue with the company or not to continue, to accept the position given to you as a special advisor to the chairman or not. So, but he did not give me an answer accepting that, and that's why at that time we did not have that information.
Thank you.
Sorry, when do you say that?
I want you to. That was mentioned by this office. One thing I should mention to you that he asked for audit reports, and we showed them the last audit reports, and he said why such transaction with this size was not referred to in the audit report, and we said to him, we didn't know, our auditors wouldn't know because only the finance department provide those information to them. So I would imagine that if the audit and external audit saw that there is a amount given to the company as a loan or as a short loan or just feeding the account, they would have to raise it and they would have to recommend not to be done again. But this never been disclosed to the external auditors.
Right.
Mr. Just a couple of matters arising from that. When do you say that this conversation between you and Mr. El Fadil occurred?
That occurred immediately after the meeting with the chairman on the 24th. Could be the same day or the day after, but it was after that meeting.
Okay. And that was before he had been appointed as special advisor, correct?
Yes.
Yeah. So you knew in advance that he would be appointed special advisor.
Of course, this was already a plan, and we just had to implement it. It was a plan, and that's why we made arrangement. That's why some people were hired, like Taj was hired with that in mind. Yes.
Just in relation to the audit, do you accept that the 1.4 million from 2013 had been included in the audit statements for those years?
Now, are we talking about the external audit?
Yeah, the external audits from 2013
Yeah.
included the amount of 1.4 million subsequently alleged to have been stolen, correct?
No.
Okay.
Which
fine.
report is that?
Well, every year Ernst & Young do
Yeah.
an audit, don't they?
Yes, external audit. Yes.
And the 1.4 million had been included in those external audits, hadn't it?
Well,
Included as what, Mr. Bowden? Because this is not a clear.
Included as expenses. It had been booked. It was there.
Yeah, it is booked and it's there. It is always there, but it was not. It was not really. It was not given to them as it was already paid as an advance for the company account in order to be able to pay others. This was not put in the report.
Are you saying it was misrepresented in those earlier reports?
I would say that the external auditors were not giving this clearly. It was not disclosed to them the way it was presented during this litigation.
And there was no opportunity for the 1.3 million to be included in the year-end external audit report for 2017 because as at the time of his dismissal, that had not been completed. Agreed?
The external audit reports did not refer to any of these.
That was not my question. My question was
1.3 was not referred to.
My question was, the 1.3 million said to have been misappropriated in 2017 could not have been included in an external audit report for that year because it had not, at the time of his dismissal, been completed. Do you agree?
It's I'm not sure about the question. I don't want to say.
One of the things, okay, put it this way. One of the things that Mr. El Fadil was working on when he was dismissed was the external audit for year-end 2017. Do you agree?
Yes, correct. I agree.
And it had not been completed at the time that he left the company on
No, it was not. It was not completed.
Yeah.
It was not.
Now, just before we move on from this document, we're still on page I-108, and it says the last paragraph, I hope I have undertaken the assignment entrusted to me to the fullest in accordance with the generally recognized accounting standards.
Okay. Yes.
Do you know what those accounting standards were? Are they referred to anywhere? Were they set out in the scope? Can they be now identified?
No, I can't tell you that I know exactly what are those standards, but they were referring to standards. This accounting is qualified and it's listed as a qualified account office with the public prosecutor in Dubai.
Now, I just want to talk about what happened next. If we can go to document A1, and it's page reference, yeah, it's document A1, but the page reference is going to be, I think it's going to be A1-54. I'm hoping. Yes.
A1-54.
4. And this is Annexure 1 to the reply and defence of the counterclaim defendant. And this was dated the 21st of November 2018. Okay?
This was part of what, this annex is part of what report?
I think this was perhaps drafted by Gibson Dunn, who were your lawyers at that time. Is that correct? Or maybe BSA?
No, it's still BSA.
Okay.
Seems BSA.
Now, this admits that SAR 1.1 out of the AED 1.344 was supported and therefore admitted, correct?
Yes, written, yes. Yeah.
And it refers to the supporting documents and all those B series of numbers that relates to the EMA Saxena report, doesn't it?
I cannot be positive on that, but I have to look at that report. But yes, this is the report by our advisors.
Yeah.
On,
and then there were a few more at the bottom, which were at that stage still denied. But do you accept that they were later accepted, and indeed that whole 1.134427717 is the amount in respect of which the judgment was set aside, correct?
yes, that's correct.
So, but from 21 November, do you accept that the bulk of the 1.3 million was accepted by your company as having been properly paid over to Mr. El Fadil?
I don't put it this way. I would put it that we received evidence that supporting those payments, and the amount that was transferred from the company account to Mr. El Fadil personal account, there is a proof that the same amount found that was transferred from his personal account to the company account in different times and in different situations. So that was admitted.
Okay. It says payments supported and therefore admitted, doesn't it? And that is correct?
Yes, Mr. Bowden, this is the report of our advisors.
Precisely. Filed in court by your lawyers.
Yes.
Go down one page, A1/55. And again, we have, this relates to the 1.4 million, doesn't it? Or no, sorry, this relates to the 610 said to have been, which was then claimed, correct?
Yeah.
And we see that almost all of that amount was then admitted.
Yes.
Okay. And that is also on the 21st of November 2018.
Yes. What is the date?
It's all in one pleading, isn't it? It's all in one
Yes,
pleading.
it is. It is all in
And the
one
date
pleading.
of the pleading was that date. Yeah.
Yeah.
Yeah, and there is a cogent explanation in Mr. El Fadil's first witness statement at page E41, paragraph 159, if it was necessary for Your Honour to check it. Now, so as at 21 November 2018, let's say 80% of these amounts were admitted by your company, correct? in the
Yes,
round.
we admitted that he brought evidence that the same amount he transferred to himself, there was amount transferred to the company.
And so in relation to the 1.3 and the 610, it could not be said at that date that there had been embezzlement of those sums, could it?
No, when we say admitted, it means that we know now that he could prove to us that same amount has been transferred to the company account.
Okay. I want to talk about what happened on the 10th of December 2018. So that is, say, there's 9 days, that's 19 days later. Agreed? 21 November to 10 December 2018, 19 days. Agreed?
Yes.
Right. Have a look. Let's go to document I5.
I5.
Yeah.
Page.
And
This is the page or
page reference I242.
I242.
And then you see there again, this, by this stage, the Rulers Court, His Highness's Rulers Court, have appointed an expert to look at the proceedings, correct?
Correct.
And this expert has been appointed by the public prosecutor, hasn't he?
Yes.
And you have paid half the fees and Mr. Abdelazim has paid the other half, correct?
Correct.
Now, can we just scroll down to, oh, and just before we move on from there, this is from your lawyers, right, to the expert, correct?
Correct.
Now, can we just go down to, it should be, I think, I244.
244, yes.
Well, just come up to I243, my apologies. The last 4 lines of I243 say thus: when the client checks with the company, the accounts will show that the client has paid its due amount, noting that he got such amounts for himself without supplying and depositing them in the bank accounts which belongs to the company. So what you're saying is that the respondent, Mr. El Fadil, took money from the company's clients and put them in his own account. Is that what's that saying?
Yes.
Okay. But does that, isn't that a little bit at odds with the admissions from the 21st of November that we've just discussed?
Yeah, that admission doesn't mean that he did not transfer from the company account to his account.
Okay.
The admission is that there was equal amount transferred to the company account.
Okay. Let's come down to page I244. Such transfers were made by the respondent in violation of the company's policy. He did not get any approval from the group board chairman on the transfers which he made for himself and the amount he got from clients in cash as well. Is that an allegation that he took cash from your clients and put it in his pocket effectively?
That's
Can you help me? I'm so sorry. I'm not sure which part of 1244 I should be looking at. Sorry,
The very final paragraph, sir.
I see. The final paragraph. Right, such transfers. Yes, I thought you were going to ask him about the first sentence on that page at 244. But that's what I was
entirely overlooked it, sir.
Well, that's why I was confused where we were. But anyway, let's stay with, you want to ask him about such transfers, and I'm there now. I'm sorry to have held things up. Why don't you put your question?
What this paragraph is saying is that he has taken cash and put it in his pocket, isn't it?
Mr. Bowden, yes, we proved that there was a cash coming, which is against the company to receive cash, and some of that cash was kept for him with a claim that he already has money due for him from the company. That happened. So we're stating a fact that one, this is against the policy, and secondly, that includes also cash that was received and kept for himself.
Do you accept that the admissions that you'd made on the 21st of November covered that cash amount?
Yes, the amount is covered. The
Okay.
transaction and the violation of the policy is still there.
Okay, come back up to the first paragraph on that page. That being said, he intentionally afflicted the company with losses and massive damages. With respect, that could never be correct, could it?
In a way, with the way we put it is that the bank account of TIG company is a bank account for a cost center where it is made to pay the dues. This bank account should have been always appropriated with funds and not to make it not sufficient to pay the dues that somebody has to feed from his bank account. And that means that it should have been a transfer from the operations in Saudi Arabia, as per the company policy, to this account in a way that it is sufficient to pay all the dues and contractuals.
Okay.
And another thing I want to add, which came to my mind yesterday, that we also have salaries to be paid for the people employed in TIG, and those salaries were paid. Now, I understand that was also maintained by transferring from the operation of the company to TIG. If that was well planned, it could have been planned for other contractual and payments.
Let's just go down to the very final sentence on I-244, and it says...
I-244, okay.
Yeah, same page. Knowing that he knows well, do you see that?
Well, this is the paragraph before the last.
It's the last bullet point on this page, and it's the third sentence in that last bullet point.
Okay.
Knowing that he knows well that this is an exception which was confirmed by the internal auditing report prepared by the manager of the internal auditing department, who made sure that there are no documents which justify or support the transfers and the payments. So are you saying that even in December of 2018, the position of the company remains that there were no documents supporting the transactions and transfers made by Mr. El Fadil, correct?
No, that's not correct. I understand that this was a report requested from our advisors to the expert to put together what was our position, and that's why they have to put it this way. Now, it was our advisors who put it, and knowing that they also have the same advisor of the IFC, and they put it this way. But this is exactly what we mentioned in our position when we had the action taken or the application made to the public prosecutors.
But you saw this report at the time it was created, didn't you?
Yes, I saw that report.
And you agreed with the content of it?
I agreed with them, the content of it, because if you read it, it was also giving him a background of why we did all these things. And I trust
Okay.
that our advisors did it in a way that it is appropriate.
Let's go down to the last
we have
sentence
to believe them.
of that first paragraph on page
Sorry, Your
I.
Honour, I didn't catch the end of the witness's answer because Mr. Bowden spoke over him again.
I was saying that if our advisors were, which they are the same advisor, even in our case in the AFC, were
Yes.
found this is inappropriate, they wouldn't put it this way.
Yes.
There is in the translation, Your Honor, a word says unclear word. It seems that when they translated, they could not come up with what is the translation. So this is something maybe change the meaning.
Okay, let's have a look at the very last sentence in that first paragraph. Did you agree with that? It says such
Which
matters.
paragraph, which page, Mr. Bowden?
Page I245, same page, same paragraph, last sentence.
Last sentence, okay. Such matter
Yeah.
prove that the respondent undeniably embezzled the company's money for himself. Yes, this is what I just said to you, that our advisors put it in that report addressed to the expert at that time, and this was the way they decided to do it.
Well, did that ring any alarm bells for you when you read that sentence?
Yes, I have to read the Arabic, to be honest. I did not read it in English. It was an Arabic report, but in Arabic report, where they mentioned that this is something that indicates it is an embezzlement. I don't know if that's accurate for the translation.
Well, that sounds as if the translation broadly matches what was said in Arabic. And I'm asking you.
In one point, Your Honor, yeah, go ahead, please. I'm sorry.
Yes, wait, you would have read this in Arabic, of course, I understand that. And when you read that last sentence in Arabic,
Yeah.
I'm asking you, did that not ring alarm bells with you? You're in charge of this litigation. You know that some days previously to this report becoming available, that in large measure the disputed sums have been accepted as sufficiently vouched for either the 610 to be paid or the 1.4 not to be disturbed. And so when you read this sentence, I'm asking you, did it not ring alarm bells?
It would, Your Honor. I read it in Arabic. If you allow me, I just want to see how they wrote it in Arabic, because I remember at that time it was saying an indication in English, an indication.
So do we have the Arabic version in the?
Yeah, we do, sir, at page I252, and it is
252, yes.
Yeah, and it is the last sentence of the second to last paragraph.
Exactly, Your Honor. It's written here, this matter is an indication that that of embezzlement, that he did embezzlement for himself. So it's indication, it's not a decision. So I don't know why in English it was made like we decided.
Mr. Jabira, would you be kind enough to read into the record what that final sentence says?
What, from the Arabic? Translation of the Arabic or this translation?
In Arabic, if you would be so.
It is I252.
Yeah.
And in I-252, you have two bulletin, the one before the last, and read the last two lines.
The last line
After the
of
comma,
second to last paragraph.
yes, after the comma, it says الأمر الذي يدل على أن المشكو ضده اختلس. So that indicates that that he embezzled money of the company for himself.
I'm sorry, I interrupted Your Honour's questions.
No, well, so that's what you've read out, of course, is what you read at the time. I just ask you one more time. I take it that did not ring any alarm bells for you, and I wonder why not.
Yes, one of them, Your Honor, is that when we were going through the report, most of it was that they are giving to the expert everything about the case, and they have to bring all the previous position that was put. Again, I'm saying that our advisors, they were aware of this more than I do, and they decided to put it this way to the expert.
I take it that there's no mention in this report of the acceptance in the pleading that we looked at, that the listed claims and listed payments in that annex to the pleading were now admitted by the company. This report makes no mention of the company's position in the DIFC claim. That's correct, is that right?
I remember there was a mention of it, and it was at that time saying in this report or the report after that, proving that the same amount has been already paid to the company account doesn't change the fact that it was unauthorized and it was against his own undertaking. I know that that was mentioned in the report. We could find it in this report or the report after.
Well, I think it's a matter of reading the report, and I'm dealing just with this report, and the court can make its own conclusion from reading the report whether there's any reference to the DIFC proceedings in this report. So we'll leave that there for the moment.
Yeah.
Do I take it, Mr. Jabera, that your answer was that the admissions you made on the 21st of November did not change the fact that he had embezzled the money?
No, I wouldn't agree with you this way, because the application that was made to DIFC, our advisors decided to make it because with the evidence we have, that the same amount was proven to be transferred to the company account, there is no need to continue that application. That's why they admitted it to stop that from being part of our claim. But that doesn't change the fact that we have an unauthorized transaction made, and the fact that even at the time we were asking the public prosecutors and the expert to give us access to the personal accounts of Mr. Al Fadil to know what was behind this kind of transactions. You know, Your Honor, that in some of those transactions, when we went deep, the time of taking the company, transferring to company account and taking it back, it was a matter of 1 day or 2 days, and that was really no explanation for it to happen. And that was to Mr. Al Fadil at that time to explain to us, in absence of that and in absence of having access to his personal account to go through it, we had that suspicion still on.
Do you accept you heard a pretty good explanation yesterday from Mr. Jatesh as to why short-term loans were required?
Yes, I understood yesterday from him that either because there was insufficient funds in the account, in TIG account, or as a priority. But this is not a decision of the company at all.
And do you accept that the payments which were made in Germany and Switzerland particularly, and for the jet, were very time sensitive?
Yeah, but that was not the norm of operation of the company.
Let's move on. I want to go
I want to explain more about this to His Honor.
Yes, go ahead.
That payment was made to the staff at that time by Mr. Al Fadil. But before that and after that, the normal procedure always been that there is a transfer to those bank accounts that appropriated for this function, and then those people would receive their dues on time, transferred from those accounts. It was not meant for anybody to feed this account from his personal account at all, and that was happening before that incident, and it is continued to happen now.
Right. Sorry, you began muted, but carry on.
I-641.
Page 641.
Yeah, page I-641 is document I-16.
I-641?
Yep.
Mm-hmm.
That's minutes of the expert on the 10th of December 2018, the same day as that report, isn't it? So what I am saying is that on the same day, that's 10 December 2018, as the report which we have just been looking at was submitted, you went to the expert and had a meeting at which you discussed that report. Is that correct?
Yes. Yes.
And
which expert, sorry, which expert are we talking about? Are we talking about the expert that was appointed by the ruler's court, or are we talking about HPA?
HH Ruler's Court expert.
Right, thank you.
Yeah, my apologies. Now, do you agree that you attended that meeting?
Yes.
And you went with your lawyer?
Yes.
Okay, thank you. Next, I'd like you to go to document I-6, and that is at page I-258.
I-258.
And then this is a further report by your lawyers to the Ruler's Court expert, correct?
If I see the first page.
Yeah, that's on 257.
Okay. Okay. Yes.
And at that stage, I just want you to come down to page I-258.
Yes.
By that stage, you had also sought the personal bank statements of the defendant from his various banks in various countries, correct?
That's correct.
Okay. And but the defendant had said that he had difficulty in accessing some of those statements to hand over because and I'm on page I-258, numbered paragraph 2, and I am 1, 2, 3, 4, 5, 6, 7 lines up from the bottom where it says further.
No, I lost here. We are on the same page?
258, I-258,
yes.
yeah. Bottom paragraph, numbered paragraph 2,
Yes.
count 7 lines up from the bottom, probably 5 from the top.
Yeah.
Further.
Such statement belonged to which bank in Dubai?
Yeah.
Further, it was turned out from the memo that the respondent did not submit his statements on the account. Okay. Okay.
Yeah. Now, what was happening there is that you had asked for his bank accounts, right? But you had refused to provide him with the letter to the bank which he needed to get them. Is that a correct statement of the position?
This is not correct. We did not receive a letter from him or from anybody for that effect.
Okay.
But what it says is different from a letter. It's saying that his residency in Saudi Arabia was already requested to expert reviewed it. So we did not. In fact, if it is part of a case, there is a procedure that you can get this information but from the public prosecutor to the counterpart in Saudi Arabia, and this could have been done.
Let's go to I-263.
And one more information I have to say that even after this statement, we did receive part of his bank account in Saudi Arabia after this.
Yeah, and so let's go to page I-263, please. And that is document I-7. I-263.
Yeah.
And that's a further memo from your lawyers to the expert, correct?
Okay.
And if we come down to page we're on I-264. Okay, by this stage, you're asking for his bank statements from Saudi Arabia, British Bank, and from Bank Saudi Fransi. So you're widening the scope of the inquiry to include his bank statements, correct?
We're not expanding anything. It was an our request from the beginning. And the expert says that for me to directly talk to the banks, I need, this is in the absence of having this from Mr. Al Fadil. The expert told us that for him to be able to directly contact the banks, he needs authorization from the public prosecutors to include it in scope, and this is what was happened.
On the 27th of February, do you accept that you went to, we better have a look at it, sorry, page I-643. I-643.
643.
643.
Okay.
643. I-643.
643. Okay.
Okay. That's a further, we're back at E16, or I-16, sorry, and that is a further minutes from, or attendance record from the meeting with the expert of that day, 27 February 2019.
Mm-hmm.
On that day, you went I see that you're industrial group vice president by this stage. Had you been promoted by that time? I think you received a promotion around that time. Is that correct?
Actually, that capacity was mistakenly put as the industrial group vice president. I was the group country vice president, actually.
Okay. Do you see that you have also taken your accounts manager there? So, right, above accounting experts signed, we've got Omar Muhammad. He's your internal accounts manager, correct?
No, Omar, Omar. No, I don't recall that was our.
Was he from HPA?
It must be.
Okay, because you did go with HPA to meetings with the expert, didn't you?
Yes, I always go with HPA. Yes.
I always go with HPA. At any time, say in the December meeting or the February meeting that we've just looked at, did anybody take the opportunity to say to the prosecutor that this claim of embezzlement is wrong? We've admitted this in the DIFC. Do you recall anybody doing that?
Yes, we did, because after the Saxena report in October, which was put in front of the expert, yes, we informed the expert that the total amount of 1.3 million was equally proven an amount transferred from Abdelazim to the company. Now it was for the expert to go through that and review it.
And is that the expert appointed by the ruler's court, or is that your expert HPA?
No, this is the expert appointed by the ruler.
Thank you. Thank you.
Now, can we go to document I-8, and that will be at I-267, page I-267. Do you see that?
267. Yes.
And that is dated the 5th of March, is it not?
Delivered is the 10th of March, it seems. It's written 10th of March.
Apologies. Okay. Now, if we come down there, at this stage, has it become clear to you that the ruler's court expert has not accepted the earlier allegations of embezzlement relating to the 1.3, the 1.4, and the 610? Do you agree with that?
Yes, we did not. He reached to the conclusion, and he put it in his report, that he found out that there is no amount due for the company from Mr. Al Fadil, because the total amount that was transferred from the company account to his account, there is an equal amount transferred from Mr. Abdelazim to the company. Except for the 610, where it was still not paid at that time.
2019.
Okay, so did that lead to a change in approach by you, as evidenced in this report of the 10th of March? This submission of the 10th of March. And I'm asking you to go down to page 273.
273.
So you've, at this stage, is it fair to say that you've scaled back the allegations of embezzlement, but you are still holding to them in relation to the identified payments in the middle column, or column second from right, that we see on page I-273, starting with row 1, 19,335.78, and concluding with, down on the next page, 1.757, sorry, I'll start that question again, my apologies. As of the 10th of March 2019, were you still alleging that the defendant had embezzled the sums which are set out in the table which begins on page I-273, continues through I-274, and ends on I-275?
I'm recalling this report, and what I know about this report was not saying embezzlement. It was saying that to prove that the same amount has been transferred, it doesn't change the fact that there was unauthorized transaction made by Mr. Abdelazim, and that he is involving his personal account with a company account in multiple transactions without authorization, without informing the company about it, and that require that we have to look at the reason why it was done, and it's our right, since he decided to involve his personal accounts, that we look at his personal accounts in full. So
okay. That's not correct, is it? What you've just told us, what you've just told the court, it's wrong, isn't it?
No, it's correct. What I just said is correct.
Come down to the page, let's start at the bottom of 276.
The bottom of 276.
I-276.
Yeah. Mm-hmm.
You're saying there that the respondent concealed the above transfers from the external auditor of the complainant upon submitting the company accounts for annual audit, which is considered to be a grave breach of professional conscience as CFO of the group. So you're not simply winding your allegations back to a lack of authority, are you? You are continuing to make serious allegations of impropriety against him, aren't you?
This statement is true.
Okay, fine. Next paragraph.
Let me explain, if you allow me, Your Honor.
I don't.
Yes.
I will explain that this was happened. I mean, the audit of 2017, which was not completed by the time Mr. Al Fadil already resigned, we completed that. We at that time informed E&Y, our external auditors about it, and they included in their management report. They said that this is something that should not happen. They mentioned that, and it was for them to be reported as a management.
But the purpose of this report was to persuade the prosecutor that crimes had been committed and Mr. El Fadil should be charged with crimes. Would you agree with that?
Mr. Honor, the purpose started by asking the prosecutor to issue a warrant that he doesn't leave the country. That was how we started. And then there was an answer from Mr. Al Fadil to the prosecutor that he did not do anything wrong. So they asked both of us to present what they have in facts to the expert who was appointed. So in that case, we gave the expert everything that we have, and we requested that not only that the transaction made, we requested to have access to his personal account to clear everything. So this was the main purpose. We never had the intention, and we left it to the prosecutor to decide if he is charged for criminal or not.
Well, what you're saying, as I understand it, is that you left the option open to the prosecutor to charge Mr. El Fadil for various crimes. Is that right?
Yes, the way we put it, Mr. Honor, Your Honor, is that we presented all the facts that we have.
And you see, the case against you is that you did that notwithstanding the admissions that were made in the pleading back in the November of 2018.
Yes. The admission that we did in November, Your Honor, was in the case of DIFC, and the advisors told us at that time that continue with this application would not get you anywhere around the reason why those transferred done, because this will be, if it was proven, it would have been criminal, and DFC will not do criminal. And that's why it decided not to continue with that application by admitting that the total amount was transferred equal to what he transferred to himself. So this is the base of this is the advice that was given to us at that time, Your Honor.
Well, as I understand it from that answer, your advisors were telling you that it was still maintainable that crimes had been committed in respect of the admitted transfers and claims in the DIFC court.
It could be that there is something that we are not aware of why those funds has been moving from the company account to his account, even though it shows that equally was returned. But to go and investigate by going through his personal account, and if we would reach to any evidence to prove our doubts and suspicions, in all cases, this could be with the Dubai court and public prosecutors, not with the DFC court. So our advisors gave us this advice not to continue the application the way it is and admit that this equal amount was transferred back to the company.
Yeah.
What you just told His Honour about the order in which the complaint was made and the passport application was made is incorrect, isn't it? Isn't it the case that you made the police complaint at the Dubai police station for the amount of 2.7 million dirhams on the 13th of May 2018? Do you agree?
Yes.
And the passport application was made 2 months later on the 15th of July 2018. Do you agree?
No, it was our application for to prevent him from traveling was from May.
Ah, Well, the passport application you made, the passport application you made to the prosecutor was on 15 July, wasn't it?
No, it's not this way.
Okay.
We did it with our advisor at that time, Global, and that was in May.
Okay, let's go
And
to
that was, if you
page.
allow me, Your Honor, and that was a result of the fact that we found out that DIFC is not the jurisdiction to apply this. So we moved to Dubai to apply it.
Can I take you to page H145?
H145.
It's for you. Thank you. Okay. Thank you, sir.
Yes,
Do you see that it's dated the 15th of July 2018?
I do.
Well, that's the date of the application, isn't it?
Yes.
Right. Okay, thank you. Can we go
I have to
to...
explain, Mr. Bowden. Allow me to explain, if the Honor agreed.
yes,
Your Honor, this was the application made with when we changed our advisor, because Global did application. They on May, as a result of finding out that they were wrong when they approached DIFC for this application. DIFC is not the jurisdiction for this. And then they did not, it seems they did not do it in a proper way. But the file with the police in May was for the purpose of preventing Mr. Al Fadil from leaving the country. So the same purpose, we replaced the advisor, and it seems they did it in a proper way, and that happened on the 15th of July.
I think strictly speaking, the DIFC court had the power to issue a passport order, but it decided on the material before it not to exercise that power in your favor.
To this day, Your Honor, I didn't know that. To this day, the advice given to us from our advisor at that time, Global, that is not the jurisdiction for it. And that's why it was a mistake even to apply. We mentioned that in our document and stated.
Well, in any event, not having obtained a passport order from the DIFC court, you then, your evidence is that in May, the decision is taken to attempt to get a passport order made through going to the public prosecutor or to the police. And your evidence is that that began in May. And we see here that there's a further application on the 15th of July.
Yeah. Yes, in May, the application was made to preventing him from leaving the country and to return the computer of the company for these two, and for misapplication or for whatever reason, our Global did not. They were not able to put a proper application, and then we had to replace them and get the other advisor, who it seems did it appropriately, but it took him until July to really reach to this application.
Yes. Now, just help me with this. After the admissions that were made in the pleading that we've seen in November, were you continuing to attempt to obtain a passport order from the prosecuting authorities or from the police? Or had you abandoned that objective after the admissions made in November?
No, we did not, and it was not even a point for us to raise. We did not, Your Honor.
You did not?
We did not.
So after the admissions that were made in November, you were not seeking a passport order?
No, we did not.
No. So I come to what your objective was in continuing to make a case through HPA to the prosecutor. And your evidence, as I understand it, is that you wanted the prosecutor to exercise various powers to compel production of documents and so on, in the hope that that might produce material that you could use against Mr. El Fadil. Is that right?
Your Honor, HPA was asked to reply to the report of Saxena. That was after the day of admitting to the IFC court. And that's why HPA were asked to reply to that Saxena report and submit it to the expert. The other thing is,
I'm so sorry to interrupt you, because I'm just trying to keep a very crisp distinction between various matters.
Correct.
HPA was originally instructed before the Saxena report came into being, and your objective then was, just getting my dates right, do forgive me, HPA were instructed before the admissions that were made in the November.
Correct.
Yes. Then those admissions are made in November, and you're not then going to pursue a passport order from the prosecuting authorities. Instead, you wished the prosecutor, the original intention was to persuade the prosecutor to charge Mr. El Fadil with crimes arising out of the evidence that you were putting forward. Then there's the Saxena report, which leads you in November to make the admissions that you made, but you continue, notwithstanding those admissions, to seek some action, can I put it that way, some action from the police or the prosecuting authority. And my understanding from your evidence is that some action was to obtain orders for production of documents and to obtain information for the purposes of seeing whether it gave you an opportunity to continue to make allegations of crimes. Is that correct?
Yes, we requested a production of document, specifically, Your Honor, the personal bank account, access to it in full, in order for us to see, one, what was behind those transactions that was not explained, and secondly, to see if there's other parties involved in this, so that it will make it, it's appropriate for the company to be aware of that. So that was the reason why
I see.
you're asking for.
And this was done on the understanding that there was a difference between the possibility of criminal proceedings and the proceedings in the DIFC court, so that it was possible that, notwithstanding the admissions that you made in November, that nonetheless there may emerge material that would persuade the prosecutor to charge Mr. El Fadil with crimes. Have I got that right?
Yes, and we were searching for that to find it.
And you were in charge of these actions that were being taken. And you understood what was being said by your expert in seeking to achieve the objectives that you and I have just identified. That's
Yes.
right. Yes.
Your Honor, the expert means the HPA in this case, you mean?
Well, no. Well, you are using HPA to make representations to the court-appointed expert.
Yes.
Yes. And the objective there was to endeavor to persuade the expert that, notwithstanding the admissions in the DIFC court, because it's a criminal, you're dealing now with a criminal in a criminal jurisdiction, the objective was to see whether nonetheless there could be criminal charges, notwithstanding the admissions that were made in the DIFC court.
Correct. So we were searching for evidence,
Yes.
further evidence to explain to us why that took place to start, what's behind it.
Yes. Yes. Well, thank you very much, Mr. Jabra.
Thank you.
Yes, Mr. Bowden.
Just as a matter of record, do you accept that you obtained the passport order from the public prosecutor on the 15th of July 2018?
Yeah, I can't exactly correct the date, but it was.
Yes, and that was successful, correct? You obtained the order?
Yes, we actually knew that after it was done. I mean, they did not send us official notes telling that we banned him from traveling, but we came to know through our advisor that this already executed.
And he got it back on the 4th of July 2019, correct? After the dismissal of the proceedings.
After the dismissal, yes, that's correct.
And it doesn't just stop you going on holiday, does it? Having your passport taken, because it stops you doing anything, doesn't it?
Well, it's a bit broad to say anything. Do you want to put any specific?
For example, do you accept that it stopped Mr. El Fadil from continuing the visas for his children and his wife? Because that's what he says in his evidence. Do you accept that?
No, I don't accept that because I know there is a procedure to make in situation like this. As far as he is banned from traveling, he can still use his passport. I asked about this later. And the way it's done is that he is banned in the airport itself. So he cannot even leave the country, but he can have a use of his passport.
But do you accept that in this particular situation, he had been directed to take his passport to the police and he had done so? You saw Mr. Abu Ghusam give evidence, and it's in Mr. Abu Ghusam's evidence that he took him to the police station with his passport in July of 2018, and that when Mr. El Fadil came out of the police station, he looked pale. Do you remember that?
Yeah, I heard that in the witness.
Yeah. And so if his passport was in fact taken from him, the gateway which you mentioned would not be available to him. Do you agree?
Yes, I agree.
And do you agree that what actually happened in this case was that Mr. El Fadil's wife and children had to leave Dubai and move to Sudan?
I was not aware of this until I saw the statement by
When you did become aware of that, did that arouse any feelings of sympathy for him on your part?
When I heard that, I asked our advisors, in case if he's not charged, and there was, and his lawyer at that time actually was representing him with the expert actually. The advisor said that he can have a use of his passport, but he cannot leave himself the country.
Okay. Do you accept that the passport order had very real consequences for Mr. El Fadil?
Yes, I accept that. What we applied for is to prevent him from leaving the country. Now how is the procedure goes, how it is done, it's something has to do with the laws and regulation of Dubai.
Now, we were talking about, you were telling His Honour in relation to His Honour's question about the, sorry, my apologies. You were telling His Honour in relation to His Honour's question about the response of HPA to the report of EMA Saxena. And I think that we had been getting to that in the bundle, and we go to I-273.
I-273.
That's that table that we were looking at, and I'll just ask you to scroll to the bottom of that, please, and down to I-277.
277.
Yeah. Now, at the top of I-277, do you see a quotation there in bold, which is taken from the EMA Saxena report?
A copy of undertaken signed by the...
No, I-277.
I am at I-277.
Is that at the top of that page, Mr. Bowden?
Okay, and the top of that page, yes.
Is it? I don't know.
Yeah, it should say this is
The fund transferred by the company to him amounting to...
Yeah.
Yes.
Yes.
That's, I think, is what you're being asked to look at. Yes.
We're all on the same page.
Yes.
Okay, that's an extract from the EMA Saxena report, isn't it?
Yeah, seems
Yeah.
yes.
And what the EMA Saxena report there is saying was in exchange for the payments made by Mr. Abdelazim, and the company transferred these funds to him. Okay.
Well, we can see that.
Yeah. Now, you were, as exactly as His Honour has said to you, asked via HPA to provide a response, correct? And if we go down the next paragraph, that is the response from HPA as paraphrased by your lawyers. Got the HPA supplementary. Do you see that? And if we come up from the bottom.
From the bottom?
Yeah, 3 lines from the bottom.
Mm-hmm.
It says, therefore, such amounts and transfers are embezzlement, and those in charge of them are not aware of them, and that is no factual and legal substantiation. So what your response to the EMA report, which says that these were payments made to Mr. Abdelazim after he had transferred the funds to the company, and the report fairly notes that it is true that he did not get explicit approval from the chairman of the board in relation to each one. The response of your advisors is to say that his failure to obtain the permission of the chairman is itself an embezzlement, correct?
Therefore, such amount of transfer and embezzlement as those in charge of them are not aware of them, and that there is no factual and legal substantiation. Yes, that was an answer to Sectional report saying, listen, I mean, at that time, yes, he did not get a written approval, but it was in good faith. So HPA is saying when we said embezzlement in our report, we say it because it was unauthorized to do this, to take money from the company to your personal account. And that's why we said this is embezzlement.
If we just take that in little bites, at that point in time...
My answer to this is, if you allow me, it was a reply to Saxena report saying that, yes, it was not authorized, but it was in good faith. So that was the answer.
Yeah.
The answer is that even in good faith, it represents an embezzlement.
To be proven. I mean, it's not a good faith. We're talking about Vice President of Finance here, and with authority allow him to transfer funds from the company account, but with policies and undertaking to follow those policies. So that's the reason why.
Just so we're clear, at this point in time, you are accepting his entitlement to repayment of the 1.3 and the 1.4. Is that correct?
Yes, we are in that application. We admitted. I cannot actually force HBA what to say to answer. I mean, these people, we cannot tell them don't mention this.
I try to ask questions which will allow you to answer yes or no, and I'm hoping that the answer to the question I just asked was yes. Is that correct?
Yes, he admitted that, and it was answered before 3 times, Mr. Bowden.
So, but what you further say in relation to the concession that there had been no explicit permission in relation to most of the payments is that that is a concession of an embezzlement or an admission of an embezzlement, correct?
The way I understood this answer from HPA at that time is when they put their report to the expert in July, they were saying that what we had is a transfer from the company account to his personal account, being a finance, without evidence of approval or without having the company know about it.
Let's look at the words. Let's look at the words.
If I would continue my answer, please, Mr. Bowden, that's why they said it is embezzlement. Now, as an answer to the office, accounting office of Mr. Al Fadil, they said at that time it was not approved, and now it's proven that it was not approved. So.
And the fact that it was not approved is, as your lawyers say, a clear and explicit declaration that there was an embezzlement, correct?
Yeah, not approved and kept, and the chairman and the board was not informed. 2 things.
I-281.
I-281, okay.
So now to say that that wasn't the only response to the EMA report, was it? Because in addition to saying that lack of explicit consent to the repayment of funds which were admitted to be owing, you also, or your HPA auditors also came up with a further allegation of embezzlement, didn't they?
Well, you better take us through it.
Tell us which document we should look at.
Yes, I can. We're at I-281.
281, yes.
Second paragraph. okay, square dot says in addition to the series of violations that the respondent committed, there is another violation. So that's a further allegation, isn't it?
Well, let's see what the
If you
allegation
allow me
is.
to read it, please.
Please.
Oh, is this the Murab?
It is
Yeah.
indeed, sir.
Yes, true.
Yeah. And you made a further allegation, a brand new one at that stage, allegation of embezzlement against him, didn't you?
It was not embezzlement.
Well, if we just come down
Now
to...
let me make that clear, Your Honor. This was our claim of damage, which was included in the IFC court, which is in
Yes,
Mirab.
I remember that.
Yeah, and it was, we were not successful with that claim. So.
Yes. Now, what I'm trying to find in this report was whether it was submitted that by reason of I'll call it the Murab situation, some crime was committed. At the moment, I can't. I'm just looking.
Page number, if I can help you, sir.
Yes, well, certainly that's what you're there for.
I-282.
282, yes, I'm there.
Yeah. At bottom of paragraph 1, this indicates the second party caused the company to waste money and lose that amount.
Yes.
Not only that, but it was found in his capacity of the director of et cetera, he made a improper payment to a supplier.
Yeah.
And then if we come down, sir, to those were said to be gross accounting errors.
Yeah.
And if we come down, sir, to page I-283,
Yeah.
and says, we come down 5 lines, sir. Therefore, this matter made the complainant make sure that the defendant committed other embezzlement and transferred them to his various accounts. Page number, say.
I see.
Where was that crime before? You just showed me. No, it was another.
I see. Let me just read that.
Yeah.
The defendant to make sure that the defendant committed other embezzlement,
Yeah.
and transferred them to his various accounts with the banks, as it's inconceivable to be an employee of a company that has 6 bank accounts in different banks and different countries, unless there is an illegal business that the respondent carries out. I see.
Yes. That's the money laundering allegation, sir.
Yeah.
But it does go further than that, sir. And then we're at the bottom of page I-283, and it says, therefore, the complainant presented to the esteemed expert attached with this rejoinder by a supplementary report that highlighted and underlined some financial and administration violations in a technical way that confirms the offence of breach of trust. Then is our keenness not to lose the rights and give everyone his right by making the complaint, give the expert time. So, Mr. Jabera, was it the case that at the date of this memorandum that you were concerned that your original complaint for the 2.7 million was going to be dismissed, or indeed had been dismissed by the expert, and therefore you wished to bring fresh complaints.
What? Just remind me of the date again of this memorandum.
Yes, this memorandum is dated 10 March 2019, sir. And so it is I-8 10 March 2019.
And this was after the court-appointed expert had reported that there was no sustainable basis for the crimes that had been alleged.
It preceded it, sir, but it had been telegraphed, one might say. So it was a moving feast.
That was before. That was before, right?
It was before, yes.
Yeah, that was before. Yes.
All right, yes. Now, I think we ought to have a break. The witness has had to deal with a number of important questions involving close study of documents and so on. And I think we could all do with a short break. I was going to suggest 10 minutes. Would you like a longer break, Mr. Jabara, or is a 10-minute break sufficient to allow you to clear your mind a bit?
I would be grateful if you make it 15 minutes.
I'm happy to do that. We'll have a break for 15 minutes, so we shall resume at 20 minutes to the hour.
May I just say something, sir?
Yes.
In relation to my what might have seemed like a gratuitous comment, that I was surprised. I was surprised, actually, sir. And I'm not making a thing about it, but there had been a discussion as to whether or not Mr. Beckley and Mr. Jabera should be listening in on the evidence. And it had been my position that they wouldn't be. I don't believe that any harm has come from it, and I'm certainly not suggesting that there's any trouble afoot. But I was surprised too. In that sense, yeah.
These depend upon applications to the court. No application was made to me that particular witnesses should not be privy to earlier evidence given. And that's it. That's the situation. Well, then 15 minutes, please. Thank you.
Thank you. Yes, I am. Thank you, sir.
And Mr. Jabbar, is he here there? I don't think he's on screen at the moment.
Apologies, I'll make sure he's back. If it's just 1 minute before you were due to return, actually. So.
Oh, is it? Oh well, then no, don't hassle him.
No, I will. That's just thinking we're not holding things up. Someone's just going to go and give him a nudge.
Right. Hello. Make yourself comfortable.
Thank you.
Yes, Mr. Bowden.
Thank you. So we just finished with document I-8, Mr. Jabera. Now can we move to document I-9? And that is on I-301, page I-301.
I-301, okay.
Yeah. And this is a memo, again by your lawyers, but this time dated at the 21st of March, correct?
I don't have this document. Mr. Fadil.
I-301.
Let me see if I. Now I'm there. Yes.
Okay. This is a memo from your lawyers, correct? But this time it's not to the expert, but it's to the Honourable Public Prosecution Office, correct?
Correct.
And in Dubai, we know the public prosecutor has a number of powers, doesn't he? One of which is to take passports, and the other one is to bring serious criminal proceedings before the courts. Do you agree?
Yes.
Yeah. Okay. And he makes the prosecution decision, doesn't he?
Who makes the? Can you repeat the question?
It is the public in Dubai when serious offences are put before the court. It is the public prosecutor who brings the charges. Do you agree?
Yes.
Yeah. And the public prosecutor has a lot of powers to compel evidence, make passport orders, as we've seen, etc. Do you agree?
Yes.
Again, now this, by the time of this report, you were aware, were you not, that the expert had rejected or was intending to reject the initial complaint of 2.7 million, correct?
No, it's not correct.
Okay. Why is it not correct?
Because in our meeting with the expert, he said, I can give you and ask Mr. Al Fadil to give copy of his bank account, but I cannot give you a full access to the bank account statement. For that, I need to be ordered by the prosecutor to do that, something like this. And that's the reason why we were surprised first that he doesn't, because our main request giving is to give us an access to the bank account of Mr. Al Fadil since we started this. So we went to the prosecutor to allow him to do that, and that was the reason behind this letter.
With regard to page I-301, bottom of the page, the 2 lines up, second line up from the bottom, or let's go 5 lines up. The complainant requested the expert to communicate with those banks to review the bank's accounts, as this will clarify some ambiguities and solve many mysteries, as there are many huge amounts that were transferred from those accounts confirming the embezzlement. So it remains your position as late as 21 March 2019 that the transfers to Mr. Al Fadil's account represented an embezzlement. Is that correct? Am I right about that?
No, not this way, because we mentioned in the same paragraph there is ambiguities, and this can only be clarified if we have an access to more information.
And so at that stage you wanted the bank accounts, is that right?
From the beginning, and I want to make that clear to the court, Your Honor, that from the beginning, this is the part that we were missing. And it was very easy for Mr. Al Fadil from the start to make that to the disposal of the company. It was the decision of Mr. Al Fadil to use his personal bank account involved in the business of the company. And it was actually a matter of cooperation from him to make that in the disposal of the company to finish their audit and to reach to the conclusion. We had that chance many times, but at least the one time I had a discussion with Mr. Al Fadil, I told him to come with all those yourself and clean your case, and he did not agree with me with the action he took after that.
What was the date of that conversation between you and Mr. El Fadil?
That was after the meeting with the chairman on the 24th.
24th of January.
That time, that was my discussion with Mr. Al Fadil, and then I said, this is in the contrary. This is even the word I mentioned is moving to the new assignment that you're going to take as advisor. This is a cleaning for you, that everything was okay when you left to that position.
Do you accept that from the date, at least, of the EMA Saxena report and your receipt of the annexures to it, that you had all relevant bank statements from Mr. El Fadil?
There was a proof of transfer for those particular cases. Whenever there's a transfer of amount, that page that shows the transfer was attached.
So as at 21 March 2019, is it not the case that you were simply on a fishing expedition intended to further delay and bedevil the proceedings which you had undertaken before the prosecutor?
I disagree with that.
Okay. You got these bank statements, didn't you? Your application to the prosecutor was successful. He ordered the bank statements be turned over, didn't he?
Yeah, he asked Mr. Al Fadil to provide it, and Mr. Al Fadil provided whatever he could bring. We did not receive a full access as we required, and not for all the banks that we required.
But in November 2019, it's the case that you went back to the DIFC courts and made the same application for bank statements there, didn't you?
Yes, that was after this request. Yes.
And that was dismissed with indemnity costs against you, wasn't it?
That was what?
Dismissed and costs ordered against the industrial group.
It was. It was.
Was that application supported by a witness statement?
Oh, yes, it was, sir.
I don't want you to take me to it now, but is that in the bundle?
It's not yet, sir, and I'm sufficiently chastened.
It may well be on the CMS as part of an event. And if it is, that's I don't want to take you out of your flow, but that's something that I might want to have the reference for.
Absolutely, so I thought about it this morning, but moving on. I-10, document I-10, page I-308. This is dated the 8th of April 2019, isn't it?
I just have to locate it. I-308. No, this is...
it's on page 1307, the date.
Yeah, my apologies.
Yeah.
And by this stage, you've got a brand new allegation underfoot, haven't you? Afoot.
Well, why don't you put to him what the allegation is?
Okay, by this stage, you're making an allegation, something to do, I think, with money laundering or similar. Do you agree?
Let me read that. Where is it mentioned?
Well, if we look at the bottom paragraph on page I-307, it says the first question raised by the complainant in its memos is it ordinary for an employee who receives a monthly salary to have 6 main bank accounts and 7 sub-accounts with different banks? Okay.
Mm-hmm.
And so you're questioning his veracity, aren't you? His integrity, and saying that that is a matter of considerable suspicion. Do you agree?
Yes, considerable suspicion, yes.
But of course, this is a man who's been living in multiple jurisdictions and working in multiple jurisdictions, hasn't he?
Yes.
And is it in fact unusual for somebody in Mr. El Fadil's position to have a bank account or bank accounts in Egypt, where he's lived, agreed, and owns property, in Saudi, where he has lived and worked for the industrial group, in Dubai, where he has lived and worked, in Abu Dhabi, where he's also operated for the industrial group, and in
Abu
Sudan.
Dhabi, I don't understand what Abu Dhabi has to do with our company.
Did he not have a bank account in Abu Dhabi, are you saying?
Yeah, but what this has to do with our company, that he's working with us in Dubai and he has a bank account in Dubai.
Let's exclude Abu Dhabi, forget Abu Dhabi, okay? Or let's talk about the rest of them. Egypt, Saudi, Dubai, Sudan. What's wrong with that? Why shouldn't he have? In fact, it would be wise to.
Refer to any bank account in Sudan, I don't recall that.
All right.
We refer to multiple bank accounts in one country and we refer to one in Morocco.
Well, and Morocco, I'd forgotten about Morocco, of course. Okay, let's move down. Page I-308. Your Honourable...
08, yes, in the bottom, yeah.
Now here you have a brand new allegation right at the last minute, just as the first one is crumbling.
Well, can you show me where it is on this page?
Yes, page I-308, paragraph 2, second paragraph. Your honourable expert must be attentive to what the respondent is trying to do. And to mislead your honourable expert and delude you into believing that he used to transfer amounts from his own account to pay amounts due from the company, and then transfer the same back to his account, which scenario, if true, would be a well-planned forecourt one that was applied by the respondent to conceal his crimes and legalise his embezzlements. Now, Mr. Jabira, that is an allegation that he has attempted to launder the thefts which he has undertaken from your company, isn't it?
Yes, that was what our advisor actually put together as and making an inquiry about why those funds in millions has been
I just ask you
moved from.
Yes, go on, Mr. Jabra. Finish your.
Moved from the company account to his account and back, and with the absence of having the explanation and to have the access to the bank account of his, this is the position that our advisors put together to the expert explaining.
at any time prior to the 4th of July 2021, had you tried to blame your advisors for putting this forward?
No, we did not blame them for this particular proceedings.
But you do now, don't you? That's what you've been saying. That this was
Well,
your
I haven't
advice.
understood. Sorry, I have not understood anything that's come from this witness. That the company, DIG, is blaming its advisors. He's told me what the advisor's advice was. And at the moment, that's really all I've heard. And Mr. Jabbar, could I ask you this? Before this memo was sent to the prosecutor, were you informed by your lawyers that this was what they were contemplating doing?
Yes.
Did they send you a draft of what they were proposing to send to him, were going to be doing, or how did they let you know that this was a step they were going to take?
Yeah, they send a draft of the letter before they send it.
And I can take it that you read through the draft.
Yes, honestly, I was actually going through the facts and dates and numbers when they talk about it, but with the with the word they use to answer it, I left it entirely to them. Especially that was in Arabic, and I was sure that when they put it together that way, that they know what they're doing.
As I see. Thank you.
Well, you had attended a meeting with the Royal Court expert on the 4th of April, hadn't you?
Yes, that could be one of the meetings. The date I'm not sure of, but yes.
Okay, let's go to document I-16, which will be
page 1.
That's the document number. Sorry, I-16. My apologies. And it will be page. Yeah, it is page I-647.
6.
So, do you see that?
Yeah.
Yeah. And again, you're there as in the capacity of group vice president?
Yes, actually, yes, I was the country vice president of the group. Yes.
Well, what's your role now?
Now I'm a special advisor to the chairman.
Is that the same position as Mr. El Fadil was promoted to in February 2018?
No, it's not the same.
Not the same. Okay.
No.
Is it higher or lower in the scale?
But I cannot say I'm a special advisor, and I said it's not the same because the area where I am able to advise is different totally from what Mr. El Fadil would.
So you're close to the chairman? Very.
Yes, I'm working in this company for so long, and I was reporting to the chairman for a number of years, yes.
And are you effectively representing the chairman and his views in this proceeding?
I don't agree with the views, but I represent the chairman. I represent him officially in some areas in different companies. I do.
And do you represent him in this proceeding? Well, what's important, it seems to me, is this. This witness accepts that he has had overall responsibility on behalf of the claimant for this litigation. And so he is representing the company. I don't think it's necessary at the moment to go beyond that.
Thank you, sir. I accept I've gone off piste with that one. Let's look at this document I-647. You're at the meeting of the 4th of April.
Well, he's agreed that.
Yeah, and my apologies, sir. And you've taken along the complainant's accountant, but I think you're saying that that is the representative of HPA
this time,
is it?
Mr. Faisal Hamid is our accountant, yes.
Okay. And so it's after this meeting at the expert's office that you put together with your lawyers, and your lawyer was there too, I note, the document that we were looking at H10, page I-308, dated 8 April 2019, correct? You go to the meeting on the 4th and you put together the report on the 8th, correct?
I have to confirm the dates here. Which report you're talking about?
Okay, you accept the meeting that we're looking at on page I-647 is dated the 4th of April 2019?
Correct.
Okay, let's go back up to, sorry, I-308.
Well, the date is on I-307, I think.
I-307.
Which page is this number?
I-307.
I-307.
I3.
And you see that you've submitted a memo 4 days later, correct?
We submitted that on the 8th of February, yes?
And
April, actually.
I am at page 1307.
Yes, well, isn't it 080419? Isn't that the date?
yeah, it is, sir. And if it is April, absolutely, sir.
It is April, yes.
Yeah. Okay. Yes, Mr. Bowden.
And that effectively, just to move on, that makes a new allegation, doesn't it? Effectively, that he's concealed a number of crimes. Now, can we go to document I-13? Well, just before we do that, on the, we'll quickly go to document I-11, and that is page I-319.
319.
And on the 28th,
319, yes.
on the 28th of April, the expert produced a very lengthy report which rejected the complaints, correct?
Yes, this is the report of the experts.
Yeah. And then on, if we come to document I-12,
Page.
I-366, if we're on page I-366, that is the memo from your lawyers dated
7th of May.
7th of May.
and in there we see you've complained about the expert's report. We're halfway down the first paragraph on the right. The expert prejudiced in the interest of the complainee in this regard is gross, alarming, passing the complainant's right. The expert deviated from justice rule. Therefore, the claimant appeals the honourable prosecution to rectify. The expert carried out the mission disregarding the provisions of the documents in a way that does not achieve justice between the litigants, and on and so forth. Do you agree that this was a very lengthy complaint which effectively made all of the same complaints again?
We made a complaint against him after he produces that memo because he deviated from the order given by the public prosecutors. He was ordered to have a full access to bank accounts as we requested it.
Yeah.
That was his demand from us, and we provided that from the public prosecutors. What we found out when we met him on the 4th of April, they just showed me the document of that meeting. He brought copies of bank account produced by Mr. Al Fadil, and he asked us to read it and analyze it in his office, not to take it with him. We brought with us Mr. Faisal, our accountant, and we found that it is not complete. It's not for all the banks that we requested, and we were not able to analyze it. He said, I'm going to give you 1 hour or maximum 2 to go through it, but I cannot do any more. We found that not going with the permission and the orders actually given to him by the public prosecutors, and that's why we made this memo complaining.
Okay. And then the prosecutor directed the expert to do a further report, and that is at I-387, and sorry, so it's document I-13, and it's page I-387.
I-38, okay, 7.
You see that? And so there's a further report from the prosecutor.
Or is
Yes.
it from the expert?
Oh, my apologies, sir. It is from the expert.
Yeah.
To the prosecutor. And if I just ask you to go down to page I-392, either scroll down or
I-392. Yes.
Yeah.
and this is really where the expert dismisses your complaint, all of your complaints, doesn't he? If we just go, sorry, back up to the bottom of I-391, it says responding to the objection. The table referred to was presented together with the claimant's point of view. The schedule, the expert investigated all the amounts and its supportive documents. And here we refer to the same to avoid repetition, knowing that a response was made with regard to these amounts. And the expert's opinion was clarified after reviewing the documents, the nature of which was shown to be sufficient for the expert to issue an opinion in its regard. And then if we come down, he said, all you've done at paragraph point 2 on page 139, I-392, the expert is saying it's what you've put together in your third memo is merely a repetition of all the documents submitted before. And then importantly, at paragraph 3, the expert says this: the claimant based the hypothesis that the respondent is indebted with the amounts mentioned only because there is no written approval of the chairman of the claimant company, although it admitted the worthiness of the respondent to these amounts. Now, that's a correct statement of the position, isn't it? Then and now.
The position of who, if I just want to understand the question.
Yeah. What I am saying to you is that what we are looking there, paragraph number 3 on page I-392, is a correct statement of the position then and now. Do you agree?
No, I don't agree.
Okay.
Because he said by not having a written approval, by not making the chairman aware of it, it doesn't mean that it is. So this is the expert, and I cannot comment on his, but the expert took mainly the opinion of Mr. Al Fadil advisor. He said that exactly.
Well, what was that? Does that reflect the fact that they were able to justify their opinions and your expert never even attempted to do so?
The facts is repeated here again, that there was no approval and it was not made aware to the chairman and the company. So these two remains facts, but he's saying that for his opinion that there is no base for us to continue with the allegation.
Thank you. Let's go down the page, I-392 to numbered paragraph 6.
I3.
Yep.
Again.
Same page, it's the same page, it's number 6.
Okay, number 6.
Is in article number 3.
Okay. The claimant, the chairman, and the officials in the company know that responded transferred. Yeah, we disagree with him in this many times, but he decided to take his opinion about it.
Well, I'd like to suggest to you that that is correct, that you always knew that these amounts were owing. What do you say to that?
This amount is what?
I suggest to you that you always knew that the amounts of 1.3 million and 610,000 dirhams were owing to Mr. El Fadil, and that you knew that from January.
Yes, but this question, I cannot answer yes or no this question. You have to separate between the two. Ask me about the 610 and then ask me about the 1.3. I cannot combine them in one answer, Mr. Bowden.
From the 22nd of January or soon thereafter, did you know that the 610 was owing to Mr. El Fadil?
After the 22nd of January,
yeah,
2018.
Yeah. Did you know?
No, I was not aware.
Did you know on the 25th of April when you saw Mr. Taj's report?
When I saw Mr. Taj's report, yeah, it was actually shown that there was a transfer to his account of 1.3, and there was actually still authorization and approval was not presented at that time.
So at that point, 25 April 2018, do you agree that you knew that the 610,000 was in fact owing to Mr. El Fadil?
No, I wouldn't know that.
When KPMG came in June, July 2018, did you know then that the 610,000 was owing to Mr. El Fadil?
That was still in April.
No, that was in, I think, June, July, but we don't know exactly. But do you accept then that you found out that the amount was properly owing?
No, you can't ask that question. When you say, do you accept then you found out, that's seeking from the witness, asking the witness to relate the conclusions of KPMG, and you can't ask that because it's privileged. You can ask the witness whether at the time KPMG were engaged and at the time they offered any view that independently of anything that was said by KPMG, the claimant knew that the 610 was owing and that the 1.3 had been the payments into his account in respect of the 1.3 were justified. You can ask him that.
Yeah. At the time that KPMG came to the offices of TIG, were you aware or made aware that the...
No,
that's
not made
fine.
aware. Not made aware.
Mr. Van knows full
yes,
well
sir.
what's going on.
It would be made aware if he was aware of what Mr. Raghavanshi said that he said to KPMG. That would not be privileged.
No, I'm
sir,
sorry.
with respect to submission.
I'm sorry. You can't ask that question. I've been
Okay.
very clear. You can ask whether, independently of any views that might have been expressed by KPMG, did the company know that the 610 was due and owing? That you can ask him.
Do you understand the proposition as put by His Honour?
I did.
And what is the answer to that?
I was not aware.
When you received the annexures to the EMA Saxena report in October, did you become aware that the amount was owing?
At that time, I was made aware that there is an equal amount transferred from Mr. Al Fadil account to the company account in many different times.
Is that a yes or a no? I don't understand.
Well, I
Yes,
understand
I
the
said
answer.
I was aware in October from the Saxena report that equal amount was transferred from his account to the company account of 1.3, that number.
Now, very well. If I could just have spend a moment with Your Honour, my next set of question. Oh, sorry, I apologise. I have one further question on that set. Can I ask you to go to document H34?
H34.
34.
We're going to get the page in a minute.
We are, and that will be
H159.
H159.
159.
Do you see there? That is the decision of the public prosecutor dated 26th of May 2019.
Correct.
Now, the prosecutor dismissed all of your complaints, didn't he?
Yeah, he dismissed that. Well, I know it in Arabic, but in Arabic it says that what presented to the expert did not make it sufficient evidence for them to file it as a criminal complaint.
Okay, and so this is actually 1 year and 13 days. So this is dated 26 May, which is just over 1 year after you'd made the complaint to the Bur Dubai police. If we look further down on page H159, agreed?
Yeah.
And then it summarizes the complaint at the bottom of page H159, says during the period of his employment, he transferred money from the company's account to his personal account in the amount of 2.7 million dirhams.
Mm-hmm.
Okay. That properly describes the complaint, correct?
At that time when we started the complaint, that was our position, yes.
And then if we just move down to H161, and it talks there about the documents that you provided supporting embezzlement, such as the internal audit report, correct?
Mm-hmm.
And then if we flick down to H167,
Yeah.
talks there about you nearly at the halfway down. It says the plaintiff replied through BSA Ahmed and petitioned for research of the plaintiff's objections and addressing the central bank to inquire about all the accounts. So is it the case that you had approached the central bank during this investigation?
No.
Okay. And then if I take you down to H169, and this is what the prosecutor concludes about this matter, isn't it? And it says, without being supported by any decisive evidence or clues which prove the incident, especially the accused kept denying since the dawn of the investigations, this was supported by the content of the accounting expert's report related to the incident, that it turned out that the accused didn't get the alleged amount, as well as not taking possession of the computer device. Consequently, the allegations of the plaintiff are unfounded and crumbling and were not supported by any conclusive evidence or clue, and the same was not sufficient to refer the penal case to the court of law. With that being said, and the papers didn't include any decisive evidence that the accused has committed the crime attributed to him, except what was mentioned above, and the papers didn't say otherwise. And because penal judgments are built on the decisiveness and certainty on the reality proved by the reasonable evidence and are not established on thinking, possibility, and abstract considerations, it shall and it must be decided in the papers that if there's no grounds for raising the penal case against the accused, Abdelazim El Shikh, El Fadil Hamid, for what is attributed to him, because the evidence is insufficient according to Article 118 of the Penal Procedures Law, number 35 of 1993.
Yes, that's correct. I can read it.
It is not just correct in what is read to you, but it's a correct statement of fact and law, isn't it?
Yes, they said there's no sufficient evidence to file a criminal complaint and to in front of the court. That's correct. This is what they said.
Thank you. Can I just have just one moment, sir?
Yes.
I was discussing with my associates here whether to replow some old ground, and I'll elect not to do that and not to trouble Your Honour any further. And
Yes.
that concludes my questions for this witness.
Thank you very much. Re-examination?
Two short questions, if I may, Your Honour.
Yes.
Or rather, two short areas. Thank you.
Yes.
Mr. Jabira, first of all, you were asked some questions about the contents of the Ernst & Young report, the EY report. You remember those? And you were asked about what EY were asked to do in looking at these payments that were made to employees. Can you tell me, what did you think they were going to tell you? What kind of thing did you think they were going to investigate and give you an explanation of in respect of those payments?
Yes, they we were expecting that they tell us if to what extent this unauthorized payments was done, and if there is any other payments that we were not aware of at that time, and that was the main part of their assignment.
And in relation to, in relation to the 1.3 million, just focusing in on that and the various payments that went into that, when you received the report, what did you understand, just in your own mind, what did you understand their conclusions to be about those payments?
Our understanding is that when they look at it,
if I can pause you there, I'm sorry to interrupt you. When you say, can I just ask you about your personal understanding of what you thought Ernst & Young were telling you about those payments?
Yes, to tell us something that maybe to show us in what ground that was taking place, and if it is going to be beyond what we found out by assigning our internal audit to do that. And their conclusion comes actually more or less saying that yes, those amounts that we found, they made actually, they looked at further amount actually, and they said was not, we could not find an approval for it.
I just wanted to ask you one other thing. You were asked about the internal audit report prepared by Mr. Taj.
Yeah.
And you were asked about a search that was made for a Word copy of that report.
Yes.
Can I ask you this? Did you make that search personally?
No.
Can you tell me who conducted that search?
I asked our head of IT to search it.
And who is your head of IT?
Muhammad Anjum.
Mr. Anjum, thank you very much. Your Honour, do you have any further questions for?
No, I don't.
I'm very grateful.
Thank you. Well, thank you very much for your evidence, Mr. Jabara, and you are released as a witness.
Thank you.
Of course, you will remain interested because you're the representative of the claimant company that has responsibility on behalf of the company for these proceedings. But as a witness, you are released. And please feel free to depart. If you'd like to stay where you are, then that is fine. But I'm going to be closing down the trial very shortly. Thank you very much. Well, now, gentlemen, we had a useful discussion at the end of the proceedings yesterday. We agreed that there would be sequential submissions and that Mr. Bowden would have 14 days. And I hope I recollect accurately that Mr. Montague Smith, what did we agree for you? Was it 14 or 21?
14 it was, thank you.
14, yes. And Mr. Bowden could have 7 days for responding to matters which were, if you like, fresh. Other than that, unless I hear to the contrary from either of you, I will say the obvious, that judgment is reserved and will be delivered subsequently, of course, to the written submissions, but subject to other pressing demands on my time, as quickly as I can manage after I have had the final rounds of your written submissions. And thank you very much for your observations and the submissions that you've made orally in the course of the trial. The preparation for this case has been demanding. There are a lot of documents. The case lines has worked well. We've been able to look at documents that can be summoned up relatively quickly. A lot of work has gone into getting material on to the system. But by the time we got really into the heart of the case, the documents were there, and I'm impressed that we were able to summon up the documents as efficiently as we did. And for those who have toiled away to help achieve that, my thanks goes to them. And so we now stand adjourned. Thank you very
sorry,
much.
sir. Apologise. I really apologise. Just on that last point, sir, the thanks should go to Mr. David True of Adelshall Goddard. He did all that work.
Well, I know that he has had a central role in handling all these matters, and the court's certainly very grateful to him and any assistance that he had from others. So thank you both.
The 7 days, unfortunately, that's not the end. The 7 days for my reply, I will be either in the air or entering a quarantine hotel in New Zealand on that day. So I leave here on the 4th and I arrive in New Zealand on the 5th. And as I worked it out this morning, I think that's the end of the 7 days. So, and I'm pretty convinced it's going to be hectic up to that. So if I could have till just a few days after that, sir, when I'm in the quarantine hotel, I think I'm.
How many days are you? How many days?
Well, that would be the 5th that I'm in the quarantine hotel, sir. So that I would be. Do you want to? If I could send it direct to your associate on the Friday, sir?
Well, tell me how many days that will be from the time that you've received Mr. Montague Smith's.
I will receive Mr. Montague Smith's submission on what should be, well, it was 14 days from yesterday, sir, but it's probably 14 days today. So I will receive his submissions on the 29th of September. And that would be.
Make it the 30th, but anyway.
Oh, well, I'm asking 8 days then, sir, if I can.
I've no objection to the extra day.
No. Well, in fact, I'll give you 9.
Wow. May I make one observation though? It's really in relation to the content and size, if I can put it like that, of these submissions. Your Honour hasn't indicated any kind of page limit.
No, but I don't want yards and yards and yards of submissions.
Thank you.
We, all three of us, know what this case is about, where the really important issues are, and these submissions should concentrate on that. You don't need to rehearse any background. We've had all that. So just go straight to the heart of the major issues in the case, and do your best to be as concise as you can.
One further point, sir. I had indicated on the 7th of July that it was my intention to amend the claim for damages, that it was 2 years income and I wanted 3 because that's how long it's been. I take it that I can approach that in my submission in 14 days' time, sir.
Well, are you asking for permission for the amendment now?
Yes, I am, sir.
Mr. Montague Smith?
I think I'd like to see the amendment in its full glory and the application and the justification for it first. Perhaps we can deal with that in submissions.
Well, I think, yes, all right. Deal with it in submissions.
Thank you, sir.
I mean, what you can do, Mr. Bowden, you can apply for permission and you can assume in your submissions that you get permission, but you'll understand that may not be the outcome.
Yes, sir.
All right.
I do. Thank you, sir.
Right. Thank you very much.
Thank you very much, sir. And thank you to my learned friend. Awesome. Thanks, Tom.
Thank you. Cheers, Roger. All the best.
Always fun.
Always lively.
Lively. Maybe not fun. Okay. What do you reckon? Do good. What?